All rise. District Court is now in session. Judge Ross.
Oh, Steve, thank you.
Do you need to speak to the council before that?
Let's find out. Okay.
Oh, that's right.
Ms. Sorry, forgive me. No. Ms. Lewis?
That's me.
Yeah, I apologize. I don't know why I'm having this problem right now. Mr. Ramos, do you need to speak with Ms. Richins before we get started?
Sure, just for a moment. If we
Yeah,
could just
why don't you
talk
take the
for-
time you need?
And by the way, Ms. Nestor is, just had a jury come back in West Jordan, so she's not going to make it. They just came back within the last 5 minutes, so
No problem.
wanted to know that she was not ignoring.
If she decides to join by WebEx, there's an audio link available.
Oh, I'll let her know.
Okay, it's
Okay,
the same link we use all the time.
I will text her and tell her that.
Okay, sounds good. Take the time you need.
She's in there. Thank you so much. You want me to pull off on letting everybody in?
I think so. Let me just check in to make sure we're okay. Those mics are live. Jeremy, we'll go on the record once everybody's seated. Thank you.
Okay.
Those mics are not dead. You can breathe for a second. The radio stations. Is Mr. Ramos, anything on the record before we invite everybody in?
No, Your Honor, I don't think so.
Ms. Olson?
No, I have a few things I want to clarify before we begin, but I hope we can invite everyone.
Okay, you do it on the record. Okay, we're ready.
even know how to get online in here.
I don't think anybody knows how to get online in here.
Okay,
Tethering to your phone is typically the better bet.
all right. I don't know if I need it, but
And Walt told me I was digitally trapped.
We're good.
Ready?
Yep.
Good, how are you? Good to see you.
Debbie, can we go on the record, please? All right, good afternoon. This is case 231500139, the state of Utah versus Kouri Richins. Can I have counsel for the state make their appearance, please?
Margaret Olson and Brad Butler for the state.
Welcome to both you and for Ms. Richins.
Wendy Lewis and Mr. Ramos from Ms. Richins, and as I said, Ms. Nestor is held up in court in Salt Lake.
Understood. Good afternoon, Ms. Richins. All right, we're here on a motion to disqualify the prosecution. That's docket 481. Ms. Olson, before I turn to defense counsel, I understand there were a few things you wanted to put on the record before we got going.
Yes, Judge, I have 4 items to clarify. The first one is, it's our understanding through counsel that the defendant has waived hearsay objections for purposes of this proceeding. And I was hoping for a confirmation on the record that Ms. Richins is consulted and agrees with that waiver.
I have that in my list. Why don't you keep going through the rest of your 4?
Similarly, a confirmation of consultation and agreement by the defendant that she does not waive attorney-client privilege. I'm here to also confirm the state does not waive hearsay. And I wanted to note for the record that we have added some additional case authority since the original submissions. We have added United States versus Hatcher, that's 323 F3rd 666, an 8th Circuit case from 2003. We provided that case to the defense on July 31, 2024, and we included it in the binder we provided to the court on August 1st.
Got it. So as a preliminary procedural note, Ms. Nestor,
Ms. Lewis,
I keep doing it, I'm
no
sorry.
problem, it
I
happens all
apologize.
the time.
There was a joint request to submit for decision and waiver of hearsay objections that was submitted. It was signed by defense counsel. It stated, among other things, that defendant has waived all hearsay objections in relation to the court's consideration of the motion to disqualify prosecution. I have 2 questions on that.
Sure.
First, does that specifically include the 18 attachments that are listed in the joint request to submit for decision?
It does.
And did you make that waiver in writing after consulting with Ms. Richins and advising her of the pros and cons of doing that?
We did.
Okay. As part of that, you were also quite clear that Ms. Richins does not waive the attorney-client privilege between herself and former counsel, correct?
That's correct,
And I imagine she was consulted about that as well.
correct.
All right. And then were you able to review that additional authority that was sent over by the state's office?
We did. I mean, we take issue with the Richins case, but we can address that at the appropriate time.
Okay, sounds good. Ms. Olson, anything else?
No, thank you.
The Hatcher, excuse me, the Hatcher case.
Understood. So we're here on defendant's motion to disqualify the prosecution. The relief requested is in order either disqualifying the Summit County Attorney's Office as the prosecution in this matter as a whole, or in the alternative, disqualifying Mr. Bloodworth as a prosecutor in the matter. The defense has the burden of production and persuasion on the motion, and they're entitled to the first and last word. Ms. Lewis, where do you want to start?
Well, Your Honor, I think that our main concern with what has been presented, and as you've already stated on the record, we agree, we waived hearsay and we accept the affidavits that have been submitted by the state in this case and by the members of Summit County Attorney's offices, officers of the court. In going through what they have presented thus far, I think the issue that concerns us the most is any finding that there would be a waiver of any privilege knowingly by Mr. Hamady in phone calls that are at issue in this.
I don't need to go that far, though, to deny the motion.
I think you're absolutely correct. And that's what I just wanted to make clear, because from our standpoint, you don't need to go that far, because what the state has presented on the record is that what happened is what we expect to happen, especially as defense counsel, when we discover, sometimes inadvertently, sometimes knowingly, that a recorded phone call has been given to the prosecution. And that is that as soon as the prosecution takes note that that is an attorney-client call, the call is immediately stopped, it's given to a taint team. I know they've represented that that's what's happened, and we don't have any evidence to say otherwise than that.
Right.
So I do believe that the issue of whether or not that privilege was waived is not relevant to the findings today, but we do think it's important that that is addressed. And yes, I do think there is another way to reach the issue in that case, because we certainly would be concerned with any kind of finding that there was any waiver on Mr. Hammond's part of privilege.
It seems to me that the findings that are supported by the evidence is that there was no intentional or purposeful intrusion into the attorney-client relationship between Ms. Richins and her counsel by the Summit County Attorney's Office or any agent of it. Do you see any error in that finding?
I don't. No.
And on that basis, I don't see a basis to disqualify anybody from that office, at least under this record. I'm not suggesting that the case is frozen in time, but on the record before me today, that is the affidavits and other attachments that are referenced in the joint request regarding which Ms. Richins has waived any hearsay objection. That there is no credible evidence that anybody from the Summit County Attorney's Office listened to any potentially attorney-client privileged phone calls other than to confirm, well, that's Ramsey, I'm moving on. Or did anything else to intrude upon the attorney-client relationship between Ms. Richins and her prior counsel or with any of you. Am I missing anything in the record before the court?
I don't believe you are, Your Honor, and our only position would be that, of course, if anything were to come up in the future,
Sure.
that would be something we had addressed at that time. But as of right now, no, I think as the court has articulated it, that's correct.
Is there anything else you wanted to say at the outset regarding the March interaction between Ms. Lazaro, jail staff, and the notebook?
I don't think we're in a position to address that, Your Honor, and as we said, Ms. Lazaro is not waiving privilege.
Right.
We weren't present when that happened, so we'll just submit what is so far in the record on that issue. We should submit on that.
I don't see any legal issue with jail staff reviewing, scanning a notebook for words, diagrams, or contraband that would constitute or implicate a safety concern.
We would agree with that. I know that in the motion filed by Ray Quinney has intimated that it went farther than that, but yes, as you said, we don't have any affidavits to support that, and we're not waiving privilege, and there's no one here to testify about that. But yes, I do believe they have the right to scan briefly any documents coming out of the jail.
Okay, all right, I'll make sure you get the last word. Ms. Olson, Mr. Bloodworth.
Thank you, Judge. We took the liberty of preparing what we consider to be a robust proposed form of order.
I looked at it.
I would like to speak to you about why I think the scope of that order is so important. As a criminal justice professional for 3+ decades, I have observed a certain practice creep into the conduct of some defense lawyers. That is intentionally placing appellate issues into a case. So if their client is convicted, they have a good shot at a second trial. Let's call this the poisonous breadcrumb strategy. I am one member of the bar who strongly disagrees with that conduct. I posit that every lawyer has an affirmative duty not to engage in conduct that would be prejudicial to the administration of justice. And for this, I cite Rule 8.4D. It is wrong for a lawyer to intentionally throw a wrench into the gears of the system of justice, to intentionally create error, to intentionally procure a fundamentally flawed proceeding for their client. As an elected county attorney, I have a sworn duty to protect the constitutional rights of the criminally accused. I have a duty to provide a fundamentally fair process. Among the many rights of the criminally accused, I am charged with protecting. The right to a manufactured appellate issue is not one of them. Ray Quinney and Nebuchadnezzar and Sky Lazaro went where no attorney has ever gone before and took the unprecedented action of seeking to deprive this aggravated murder proceeding of every single attorney of record on a single Friday afternoon. They withdrew and they moved to disqualify the entire prosecution.
So this is where I need you to slow down for a second. Sky Lazaro's motion to withdraw was not because of any of her conduct. It was an imputed conflict from somebody else in a large firm. And so I need you to stop just short of going too much farther down the road of alleging a dial and dash kind of plan here. Let's just stay focused on what was in the motion and what evidence there is, if any. Why do I need to make findings regarding the content and circumstances of communications that your office hasn't listened to?
Because the motion sitting in that record, if not addressed now, if not addressed thoroughly and cleaned up now, is the equivalent of an undetonated grenade in this record.
I respectfully disagree if the court finds there was no Sixth Amendment violation because there was no intrusion into the attorney-client relationship. And there cannot be any intrusion under the evidence in the record before this court. It simply didn't happen. Regardless of what Ramzi Hamidi did or didn't say, or what Ms. Richins objectively or subjectively believes the circumstances of that call were with respect to confidentiality, the evidence showed Mr. Bloodworth didn't listen to him, and that jail staff did not read the substance of that notebook. That's it. I can understand why your office is really pissed about the content of that motion, but that is not enough to form a Sixth Amendment violation.
It's not. There's no factual basis, there's no legal basis, and it was done for an improper purpose. And while those unfounded allegations are of the utmost concern to this team, protecting this record is our primary goal. And I believe that this is what Your Honor needs to do. We have thought long and hard about this. It has been a real burden to try to work through this with this sitting unresolved in our record. And I agree, correcting the record begins and ends with one simple and essential truth. We didn't listen to the calls.
And did not read the contents of the notebook that was alleged to be attorney-client privileged notes from Ms. Richins to her lawyer at the time. Right? We can acknowledge that if that had occurred, we'd be having a different conversation. There's no evidence that occurred. And there's no objection from the defense to reasonable scanning of documents going out of the jail to make sure they do not contain safety concerns or contraband. You are right on the law.
Judge, I am accountable to this community. The community, Eric Richins' family, and the defendant deserve to know with certainty that there has been no intrusion into the attorney-client relationship. And I believe the proposed findings of fact and conclusions of law that we've submitted to the court
Pause
do
for
that.
1 second. Do we need to let somebody in? You got it. My apologies, Ms. Wilson. Keep going. You are accountable, as am I. And Ms. Nestor, Ms. Lewis, and Mr. Ramos are accountable to me and to the bar. We are all accountable to somebody here. There is no credible evidence of any intrusion by your office or anybody in it or any agent of it into the attorney-client relationship between Ms. Richins and her current or former counsel. That is the end of the motion.
May I recite a few of the findings I would like to see in the order?
I've read them, but you can if you'd like.
Okay. Ms. Richins and Mr. Hamady knew their calls were being recorded. Because the recordings existed, their production and discovery was compelled. Just because the recordings exist does not mean anybody listened to them for the reasons, and I thank you for the
Correct.
reasons you said. The prosecution did not listen to them and diligently sidestepped them. The allegations by Ray Quinine-Ebeker and Sky Lazaro are speculative at best and bad faith at worst. The conspiracy alleged that jail personnel are intruding into the attorney-client relationship and sharing information with the prosecution is speculative at best and bad faith at worst. There has been no per se Sixth Amendment violation. The 34 calls are not protected communications. I want to go there. The presence of a recording device destroyed any privilege that may otherwise have existed. There was no intrusion into the attorney-client relationship. The prosecution never became privy to any attorney-client communications. And the timing of the motion to disqualify, 5 months after Ray Quinine-Ebeker discovered the existence of the 34 recordings in the discovery file, 5 months after the email that contained swift and categorical assurances by myself and the chief prosecutor that no such intrusion had occurred, and 3 months after the disturbance at the jail is a standalone basis for denial because of the timing and because it can be viewed as a manipulative litigation tactic under the DJ investment group case. I would like those findings, Judge, and I think the rub between myself and Ms. Lewis is simply that finding that, it's the Hatcher case, the new case.
You're asking the court to rule as a matter of law that any communication made by Ms. Richins to her counsel outside of the protected arm of the home wave system is automatically a non-confidential communication. I'm not prepared to do that. And I don't need to, because the evidence shows your office did not listen to it, which was the correct response. And so we don't need to go down that law. The implications of that broader ruling might be difficult for me to see around those corners at this point. I'm not doing that though.
And I do need to place on the record another thing. After this defense team was appointed, they asked that if we would cause the team's attorney to remove those 34 calls from the discovery file, and he did do so, and he is in sole possession of those. I wanted to make that clear.
I appreciate that.
Okay, that's my request. I'll wait and see what your order says.
I understand. Anything else? Okay. Ms. Lewis.
Your Honor, I don't think we have anything to add. I mean, you've addressed our concern, so unless you want me to say anything more about the waiver of privilege, we don't have anything to add. We just submit.
Okay. The issue before the court is defendant's motion to disqualify the prosecution. Defendant requested in order either disqualifying the Suffolk County Attorney's Office in whole or disqualifying Mr. Bloodworth as a prosecutor. The factual allegations on which defendant's motion is based are twofold. First, that Mr. Bloodworth listened to certain attorney-client privilege communications between defendant and one of her attorneys, or prior attorneys, Mr. Ramzi Hamidi. There's no credible evidence that Mr. Bloodworth or any other agent of the state has listened to any attorney-client privilege communication between defendant and her counsel, other than a few occasions on which Mr. Bloodworth listened to the minimal amount of time necessary to identify Mr. Hamidi as a participant in the call, and after which Mr. Bloodworth promptly stopped listening and moved on. The second factual allegation upon which defendant's motion is based is an incident on March 26, 2024, during which jail staff, specifically Sergeant Thomas, would not allow defendant to pass a notebook to her counsel, prior counsel, Ms. Lazar, until after jail staff had read each page of the notebook. And there's no credible evidence that Sergeant Thomas did or even attempted to read the substance of any page of the notebook, as opposed to merely scanning the pages for words, diagrams, or contraband that implicated a safety concern for the jail or jail staff. Based upon an independent review of the record, the court finds that neither Mr. Bloodworth nor any other agent of the Summit County Attorney's Office has intentionally or purposefully intruded upon the attorney-client relationship between defendant and her counsel. And the Summit County Attorney's Office has not directed the Summit County jail staff regarding the conditions of defendant's pretrial detention. Based on those findings, the court concludes that no per se violation of defendant's Sixth Amendment rights has occurred based on the conduct of the Summit County Attorney's Office. And based on the record before the court, disqualification of Mr. Bloodworth or any other attorney in the Summit County Attorney's Office is not necessary to maintain the fairness of these adversary proceedings. In sum, defendant's motion to disqualify is without credible basis and is denied. The court will issue written findings of fact and conclusions of law to preserve an appellate record, and will issue that written ruling in the near future. Ms. Lewis, anything else on the motion?
No, Your Honor.
Ms. Olson?
Thank you, Judge.
We have a preliminary hearing coming up At the last scheduling conference, I asked you whether there were any evidentiary issues or stipulations that we needed to address in advance of that. Have we made any progress, Ms. Olson?
Well, as Ms. Lewis said, Ms. Nestor's been in trial. We are going to be working on that and fully anticipate we'll be able to have it defined prior to the beginning of prelim, so you're on the notice.
If we have a discussion, I'd like to have it prior to August 26th, so that neither side has any surprises the morning of. And so if I need to fit you into my schedule during the week of August 19th, let me know.
Understood.
Okay. Ms. Richins, barring that, I will see you again on the morning of August 26th. I wish you the very best of luck. Okay. Court's in recess. Thank you, folks.